Yes, Mr. Fix.
Thank you very much, my lord, my lady. I'm going to deal with two matters, ground 3 and the Secretary of State's response to the respondent's notice. The respondent's notice point is relevant to ground 3, so we're all agreed it's sensible to deal with it in the context of ground 3. Given the time, I'm going to have to jump straight in. The starting point in respect of the Secretary of State's submissions on ground 3 should be the 3rd of February judgment, which begins at page 72 of the court. The relevant passages for the purposes of ground 3 are paragraphs 11 to 16 that begin on page 75. So in those passages, the Upper Tribunal explains why, in its discretion, it considered it was appropriate to order the respondent's immediate return to the United Kingdom, or return subject to a short timetable, I should say. Applying the approach in a case called YZ China, and paragraph 49 of that decision, which is set out at paragraph 10. So at paragraph 11, my lady, the tribunal acknowledges that there are a number of factors that have a bearing on whether to grant a mandatory order. At paragraph 12, the tribunal states that the strongest factor in favour of making a mandatory order is the fact that the Section 94 certificate has been held to be unlawful, and the consequence of that is that the respondent has been deprived of a right of in-country appeal. At paragraph 13, the tribunal identifies the strongest factor against making a mandatory order as being that the applicant's removal was apparently lawful and in the course of making that, identifying that factor, the tribunal acknowledges that there is a valid deportation order in effect and that the respondent had been refused interim relief seeking a stay of his removal. At paragraph 14, the tribunal sets out what it explains tips the considerations in favour of the applicant. And it identifies 3 factors. Firstly, if you like, the nature of the applicant's, of the respondent's claim, and the fact that he has been recognised as a victim of trafficking and modern slavery. Secondly, the judge says it is not relevant. This is 7 lines up from the bottom of paragraph 14. It's not relevant to the judge that the respondent has failed to provide evidence that he has experienced harm or that there's an imminent risk of harm. And the context of that point is the argument that was made before the judge that the respondent had been removed to Albania in January 2025 and had not put forward any evidence indicating that he had experienced any difficulties in that country. The third factor that the judge said tipped the scales is set out in the last sentence of paragraph 14. It's the respondent's acceptance that the appellant's acceptance that the respondent will be returned in order to give effect to the Upper Tribunal's judgment and order. And at paragraph 15, the judge deals with the submission that it was a relevant factor that pointed against making a mandatory order, that the Secretary of State had agreed to return the respondent to the UK, but only after the respondent's appeal rights were exhausted. The judge discounts that consideration for the reasons given at the top of page 76. And then finally, at paragraph 16, the judge makes an observation that, if you like, she is not dealing with the mechanics of how the Secretary of State will effect return. Now, in my submission, that assessment is flawed by a failure to consider or to give reasonable weight to 4 factors. Firstly, the judge wrongly discounted the significance of the Secretary of State's lawful position that the respondent would be returned to the United Kingdom, but only after appeal rights have been, the Secretary of State's appeal rights have been exhausted. It is not disputed, as I understand it, that that was a lawful and rational position for the Secretary of State to take. And in my submission...
Does that mean he would have pursued his appeal out of country?
No, so he would have...
Appeal rights against this?
Yes, I'm sorry, so the Secretary of State's rights of appeal in respect of the Upper Tribunal's judgment.
In respect to the certification point?
Yes.
Because the whole point about the certification was whether or not he had a right of appeal against the other stuff.
Absolutely. So we accept that the applicant, the respondent needs to be in the UK in order to exercise that right of appeal.
Against the substantive? Against
the substantive refusal of the human rights and protection claim.
So we're looking at this in a context where the respondent, as you know, had been out of the country for just over a year.
Without any evidence of any difficulties having been suffered.
Well, that's a separate point, and yes. The judge made what seems to me to be a fair point, that we don't have evidence about what his circumstances have been. But sticking just for the moment with the neutral context, what was at play here was an application for relief which involved the return of the respondent to this country a year after he had been lawfully deported, at a time when you had indicated a decision that you would apply for permission to appeal.
Yes. From
the substantive decision. So that's the framework within which this was all happening.
That's right, my lord. And so the first error that the Upper Tribunal made in my submission was failing to give any weight, let alone reasonable weight, to the fact that the Secretary of State had reached a reasonable decision as to how to give effect to the Upper Tribunal's judgment. As I've indicated, it doesn't seem to be disputed that the Secretary of State did reach a reasonable and lawful decision in that regard. And in my submission, because of the proper role of a judicial review tribunal or court, that factor needed to be given very great or at least significant weight. And to support that point, I would refer the court to the Shah case, which is in the bundle of additional authorities. It begins at page 36 of that bundle. And the relevant passage is on internal page, is on internal page 350E to H on page 77.
Hold on a minute. Have we got this in hard copy?
Yes, you should do.
I can't get into my Wi-Fi at the moment, so I can't get into it.
Very well. Tab 7. For those of you using hard copies.
I've got authorities through to tab 25.
you should have an additional bundle of authority. I'm so sorry for that. We should
Does
have
anybody
checked.
have a spare report?
Yes.
I do.
Please, sorry about that, but I think I only get onto Wi-Fi if somebody hovers around.
Not at all, my lady. It came in fairly late and these things happen. I'm sorry about that.
Thank you.
Thank
So-
you very much.
so it's
Sorry, which tab was it?
Tab 7, my
Thank you
lady,
so much.
begins at page 36 for those of you using the electronic one. And the relevant part is on page 77. Between line marking E and H. And the passage that I draw attention to is the sentence beginning, "My lords, I think that is the appropriate relief." And the following sentences. And I'd also draw particular attention to the sentence just above line marking H. The function of the court is to ensure due observance of the law, that is all. So in the light of those points, the House of Lords decided that it was not appropriate to mandate that a particular decision be taken, or even to declare that there was a right to a particular decision on the facts of that case. The appropriate form of relief the House of Lords identified was a quashing order and a mandatory order requiring a reconsideration in accordance with the law. And in my submission, those observations about the nature of the court's function explain why it was highly relevant that the Secretary of State had taken a lawful decision as to how to give effect to the Upper Tribunal's substantive judgment in this case, when the Upper Tribunal came to consider whether to make a mandatory order in this case. The second fact, I should say, the Upper Tribunal does not engage at all with that consideration. The reasoning at paragraph 15 is, with respect, difficult to follow, and certainly in my respectful submission does not show that that factor was properly taken into account.
Give us the 4 points.
Yes, so firstly, Secretary of State's lawful decision to return the...
It's got that. We've got that. So,
Right.
I mean, it just, you
Very good. Second point, the absence of evidence of difficulty or harm experienced in Albania. The judge did look at that at paragraph...
that's the point.
That's the
We
point.
can ask you more
Very
if
well.
we need to.
Third point, the effect of the deportation order, which was to prevent entry. Section 5, subsection 1 of the 1971 Act, while it remained in effect.
Right, so it was inconsistent with the deportation.
Yes, and that was a point that was explicitly made in writing.
Yes.
And finally, the public interest supporting the deportation order and in maintaining the respondent's deportation. None of those factors were adequately engaged with in my submission. The first factor wasn't considered properly at all. The second factor was mentioned at paragraph 14, but it was discounted by the judge on the basis of an assertion that the respondent did not need to put in evidence about difficulties he had suffered in Albania. But in my submission, that's effectively a negation of the relevance of that factor, and that was an error of law. It was a relevant consideration. And although the judge did refer to the fact that there was a pending deportation order,
Let's pause on 2 because it's a discretionary exercise, so you say that it's one of the factors that needs to be taken into account on a balancing type
Yes.
approach. 'Cause
Now-
it's an interim relief. No, it's a final order, isn't it?
the final order, the correct approach that is binding on this court, we accept, is that set out at paragraph 49 of YZ, which the judge did apply. There, Lord Justice Richards explains that there is a broad discretion.
Yeah.
But in my submission, that discretion is not entirely open-ended, and the factors I've identified are, on any rational view, relevant considerations that needed to be looked at in this case. So I was just dealing with the point about the deportation order and its effect. At paragraph 13, the judge does refer to the fact that there's a pending deportation order which was lawful, but the judge says no more about that. She doesn't acknowledge that on the face of the statute, section 5.1 of the 71 Act, prevented the return.
Well, to be honest, Mr. Briggs, you've had your time. Thank you very much. And these are points which are very straightforward to make.
They are indeed. Can I just very briefly respond to the respondent's notice in a single point? The respondent's notice argues that the judge below should have accepted that the respondent had been unlawfully removed. That is wrong, because the AB decision of this court, which is at page 411 of your authorities, I obviously don't have time to take you to it, we say remains binding on you, with great respect, despite the Supreme Court's decision in DN, and certainly was binding on the Upper Tribunal. And in any case, it is wrong to say that the respondent's removal was unlawful, bearing in mind, for example, that Section 78 of the 2002 Act did not apply so as to preclude removal because of the Section 94 certificate. But
right. Well, Mr. Briggs, I'm sorry to talk over you yet again, but you'll have a right of reply if we don't run out of time by then,
yes.
In relation to the respondent's notice. But all of this after lunch is eating into the respondent's time for this appeal. So I think we'll draw a line there. Thank you. Yes, Ms. Lord.
Thank you very much, my lord. So I know with timings, is the court planning on rising at 4 today?
We never rise at 4. We'll sit if need be to 4:30, which will mean that your presentation will finish by 1:15.
I'm very grateful.
I mean, this is not, in a sense, take as much of that time as you want. We won't criticise you for falling short, but we won't be able to allow you to go longer, 2 hours or thereabouts.
No, I understand that, and thank you very much. My lord, if I can divide my submissions into 2 parts, the same with the respondent. First of all, I'm going to deal with the question of certification, and then I will deal with the question of the mandatory order. And when I deal with certification, the respondent's summary position is that the clearly unfounded certificate, the threshold is one of the highest thresholds in law. As we've already heard, it means a claim is bound to fail. There is no binding case law upon a hypothetical immigration judge determining an appeal. The case law that there is accepts that in certain circumstances there may not be sufficiency of protection in internal flight for certain individuals. The Secretary of State's own evidence accepts that certain claims can succeed, and in light of that, the Upper Tribunal, which is a specialised tribunal, came to a decision that was fully open to it. I'm going to structure my submissions, first of all, very briefly taking you to some of the case law. I'm very grateful to Mr. Payne, who took you through it in considerable detail, so I'm not going to go over the same ground. What I want to do is highlight a few additional points that either were not covered or I feel need a different emphasis. I will then look at the facts of the claim. And again, Mr. Payne has gone through the facts, but there are additional facts. Again, you will be unsurprised to hear that I wish to draw to the court's attention. I then go through the decision, again in brief, before coming to the judgment of the Upper Tribunal. And hopefully by structuring it that way, I will be able to be relatively quick by the time I get to the judgment. Now, the first point that I do want to emphasise, and it is set out in my skeleton argument, is the fact that this is an appeal from a specialised tribunal. It is a judicial review, so it is a point of a public law, but is nonetheless from the Upper Tribunal that Parliament has decided should have jurisdiction to determine both statutory appeals and judicial reviews in the area of immigration. And that special expertise is, I would submit, even more heightened when one is looking at a question of certificates clearly unfounded. Because the test, as we've already heard, is whether the claim is bound to fail before a hypothetical immigration judge. So it is very much in the realm of the specialised knowledge of the Upper Tribunal.
Why?
And I've referred...
Sorry, why is it within the realm of specialised knowledge? We're looking to see whether there's any evidence which could justify a finding.
Because the specialised knowledge of the immigration judge is on sufficiency of protection, on internal flight, on country guidance case law, and whether, taking all of those factors into account, whether the claim would be bound to fail. In those circumstances, it's not different, or it's very slightly different from a statutory appeal determining the appeal from themselves, especially bearing in mind, we've heard, and it's accepted by my learned friend, that the tribunal, the decision maker, does have to look at it and decide for themselves whether it is bound to fail. It's still technically a review, but that question still has to be answered by the tribunal. Could you at some stage do it whenever it's convenient to you, but just touch on the point that we briefly heard Mr. Payne on, which is, whose decision are we most interested in here? Is it the Upper Tribunal, or is it the original decision? Well, I would submit we can't look at those in a vacuum. So this is an appellant jurisdiction, so it's the appeal from the Upper Tribunal.
That's right, but I mean, in every appeal that we hear from the Upper Tribunal in a conventional immigration case, not a JR, we're really looking at the decision of the FTT. We look beyond the first appeal court to the trial court.
Yes.
And so I think at some point, I mean, you're giving us that help now, but I just want to get a clearer focus. In a case where it's been said variously that there's one right answer, or that it's black and white, and so forth. Who should we be mainly focusing on? Instinctively, I have to say, it seems to me to make more sense that one focuses on the original decision, because that's the meat and drink of this. The Upper Tribunal decision seems rather to be the dessert, that it's a commentary on the original decision. So are we going to base our decision on our views of the commentary, or are we going to base our decision on our views of the text?
So there still has to be a gateway, I would submit.
Oh, I realise that we're only here because it got to the Upper Tribunal. So that's true.
So I think that the court would have to find that the decision was wrong in some way.
Yes, but if our view, having looked at the original decision, was that that this was a hopeless application for JR in the first place, yes, then it would really only be a question of saying so and articulating why we disagreed with the UT about it.
But in those circumstances, my lord, you would be finding that the Upper Tribunal's decision was irrational, because it's a black and white test. There is... Well,
I saw it was expressed like that. I mean, why can't we just say it was wrong? I mean, I appreciate irrationality is a term of art, but wrong is enough.
Yes, I mean, if the court finds that the decision is a correct decision, is a legal decision, is a permissible decision, that the claim was bound to fail, then the Upper Tribunal's decision that it is not bound to fail must by consequence be wrong.
So if we approach it in this way, that one could get into this either by going in through the upper tribunal and then back to the decision, or going to the decision and going on to the upper tribunal, and doing an iterative process of that kind, one way or another, we will reach a conclusion. Or is there one more correct way than the other in your submission? I realise it's not easy.
It's not easy. I mean, there is, as the court have already seen, there is somewhat of a conflict in the case law. On the one hand, it being accepted that it's a review, but on the other hand, saying that it's a black and white test and there's only one decision which can be rational. My submission would be that you should reach the same result. So when one is looking at the initial decision by the Secretary of State or the tribunal decision that it wasn't bound to fail, the conclusion it wasn't bound to fail, they should lead to the same direction. They should lead to the same decision.
Can I just ask one question? If you turn it on its head, what do we do if we decide that there is a material error in the upper tribunal judgment, but you would wish to say, well, there's still a wrong decision at first of the decision matter? When you say it should be the same result whichever way we go, but that might make a difference, because you don't want us simply saying, well, we found an error in the upper tribunal's judgment and therefore it's got to be set aside. You want us, both parties want us to look at the substance of the issue, which is whether this was a case that should have been certified.
So if you find that there is an error in the decision and therefore find that it is wrong.
Well, I was talking about an error in the upper tribunal.
Sorry, in the upper tribunal decision, and find it wrong, then that would be the gateway to determining whether the claim is bound to fail. And in fact, you'll see that happened in SP Albania, where the court considered it for themselves. And in fact, it was a point in SP Albania that hadn't really featured very much below, but the court accepted that on the basis of evidence that hadn't been properly looked at, it meant the claim was not incapable of succeeding, and on that basis substituted the decision and quashed the certificate.
So make it for ourselves. So if we find an error, I don't know if we will get there, but if we find an error in the upper tribunal that's material, we could set aside that decision and make the decision ourselves on whether there was a problem with the Secretary of State. That's quite a complicated way of getting
I think in those circumstances we would have to constitute ourselves as a divisional court or something of that sort. But I mean, it does.
No, I don't.
But
No, I think we have the powers, all the powers of the court below.
I mean, I think you will see in both FR and in SP, it was substituted, and so the certificates were quashed on appeal. They weren't remitted back to first instance.
I don't think anybody would have much enthusiasm for remitting this back.
It's easier to quash than to substitute.
Yes, yeah. All right. Well, that's given us a sort of tour d'horizon of some of those possibilities, and I'm sorry to have interrupted you, but it's just helpful. And what I'm really anxious to find out is that if either party feels very strongly that we should be going through some process rather than looking at the substance, then we need to consider that carefully. But
my lord, could I just turn my back on you
yes.
just for 1 second? Thank you very much for that. So if I can,
right, you were with the point that we ought to, and of course we do pay respect to the decision of a special tribunal in these circumstances.
Yes, and I was in the course of referring you to AH Sudan, which is at tab 7 of the main authorities bundle. And I'm sure lordship and my ladyship is very familiar with it. But at paragraph 30, page 84 of the authority, you see the Baroness Hale well-known guidance about how to treat decisions from specialised tribunals. C. So it's at starts at C.
84. What page are you on?
Sorry, page 84.
Thank you so much.
That it's an expert tribunal charged with administering a complex area of law. Ordinary courts, second point, should approach appeals from them with an appropriate degree of caution. 3, and this is perhaps opposite in this case, it is probable that in understanding and applying the law in their specialised field, the tribunal will have got it right. They and they are alone are the judge of the facts. I appreciate that's not relevant to this point because the case was taken at its highest. 4, their decision should be respected unless it's quite clear that they have misdirected themselves in law. And 5, appellant's court should not rush to find such misdirection simply because they might have reached a different conclusion on the facts or expressed themselves differently. Now, if I turn now to so that's a context I would submit that the appeal has to be considered within. If I can first of all, very, very briefly deal with the statutory context, because there have been some changes to the statutory context since several of the cases were promulgated. So this is an appeal, a judicial review against Section 94, a certificate issued under Section 94, and that is at tab 1 of the authorities bundle. And you'll see 94.3a, a person may not bring an appeal under Section 82 against a decision if the claim to which the decision relates has been certified under subsection 1. And you'll see that that was inserted F5. If we turn to page 6, the textual amendments, you'll see that that was inserted by the Nationality and Borders Act 2022. Now, the reason that is relevant is because prior to that date, even when a claim was certified, an individual had an out-of-country right of appeal. So you may have already seen that in some of the authorities. There's a reference to, there's emphasis being placed on an in-country right of appeal. And that's relevant particularly when one looks at the discretion for return. Because in all of the cases, I believe, that are in the authorities bundle, there was an out-of-country right of appeal. This has been removed now. If your claim is certified, or certainly if it's certified under 3A, there is no right of appeal at all. And once it is, once an individual has been removed, there is no right of appeal overseas. So even if the certificate was then quashed, so the certificate disappeared, an individual wouldn't then have a right of appeal from overseas. And the reason for that is contained in section 92 of the Nationality and Immigration Act 2002, which is at tab 4 of the Supplementary Authorities Bundle. And it's 94.2, which just confirms that in the case of an appeal under section 82.1, protection claim appeal, the appeal must be brought from outside, must be brought from outside the UK if it's being certified under 94.7. That's the safe third country provision, but otherwise it must be brought from within the UK. So there's no out of country right of appeal.
So if there's no certificate, he has an in-country right to appeal. Is that right?
Yes. So no certificate. So if the certificate hadn't been attached at the end, the decision would have been a refusal of a protection claim and a refusal of a human rights claim. And he would have had an in-country right of appeal under section 82. And section 82, if you do need it, is at tab 3 of the additional authorities bundle. So we would have had an in-country right of appeal, but the certification removed that right of appeal completely. So it's page 17 is the section 82. Now, if I move on to the certification test, and
before
that
we leave the statute, could I just try and link, if we go back to the main authorities bundle at page 3, which is section 94 itself, and we go on to the end of that very long section,
yes,
we have some helpful footnotes, which are at F4 and F5 in the textual amendments box at the bottom of page 6. So I think we find there that 94.3 came in that form in October 2014 and 3A in June 2022.
yes. So as I was saying, prior to October 2022, there was a right of appeal, but it was out of country.
Right, so the tightening up, as some would put it,
Yes.
to remove any right of appeal came in with 3A in June 2022.
That's right. So if I move on to the certification test, and as I've already stated, I know a friend has taken you through the authorities, and I don't think that there is any disagreement with us as to how it is to be applied and how it is to be approached. There's various ways in which it's been expressed, which I think you've already been taken to, whether on one legitimate view it can succeed, whether it is bound to fail, which is perhaps the easiest test to understand. And although it is a review, as we've already heard, it is a black and white test. So there's only one answer when there is no dispute of fact. I think that's the clarifying point. I just want to take you to 2 additional points which weren't covered in my learned friends submissions. And the first of those, and my friend referred to the need for anxious scrutiny. Of course, anxious scrutiny is always applied when considering asylum appeals, and perhaps it's even more heightened when considering certificates. And what does anxious scrutiny mean? Well, can I take you to YH Iraq, which is at tab 10, paragraph 24, which is at 189. And it's the 5th line down, that it's by usage acquired special significance as underlining the very special human context in which such cases are brought, and the need for decisions to show by their reasoning that every factor which might tell in favour of an applicant has been properly taken into account. Now, the second point that I want to highlight with certification is the difference between refusing a claim and certifying a claim in the body of the decision letters, because I appreciate there was some discussion earlier about what was meant by the Upper Tribunal's reference to the failure to explain why the test was not met. And that was covered in FR, which we've already looked at in quite a bit of detail. So it's at tab 16 and paragraph 96.
Are you going to give us the page?
Yes, sorry, it's at it's page 403, but the paragraph, the section I'm going to refer you to is at 404 over the page. sets out that the importance in the circumstances of a particular case, for the reasons given below, I consider they're problematic. That's when the decision maker simply says it's bound to fail. And they highlight the importance of giving separate consideration to the decision on an application for asylum where the Secretary of State decides it should succeed, and the decision on certification where she has to decide whether this application is clearly unfounded,
I'm
so
really
that
sorry,
it's bound
where
to
are we?
fail. Sorry?
I'm so sorry, it's my fault. Where are you?
It's 404,
Yes.
and it's at the bottom of the top paragraph, which is it's paragraph 96, which starts over the page. And why that is important is because, as we can see from the decision letter, the Secretary of State, in order for a claim to be certified, the Secretary of State must have refused it. So the majority of the refusal letter will give the reasons why a claim is refused. But a claim that is simply refused carries with it a right of appeal. And what FR Albania was emphasising is that when it comes to certification, in the section relating to certification, the decision maker must explain not simply why it's been refused, but why it is not capable of succeeding. So why it meets that higher test, one of the highest thresholds in law.
Just a minute, it's an important submission. Well, could you elaborate on a situation where, not necessarily anything to do with this case, where a decision is, an administrative decision is taken, which gives, 7 or 8 conclusions dealing with the number of claims that have been made or whatever. There's a range of reasons in which all of those matters are decided adversely. And then they go on to consider a question of whether or not any claim to the tribunal would be bound to fail.
Yes.
What are the range of processes that a decision maker might go through in explaining their reasons for that? I mean, in some cases, I suppose it might be, I've been through and explained why I reject this reason, that reason, or the other, and I found your arguments to be extremely weak.
So
now, is that as an instance? Is that compatible with the duty?
So I think it would have to be more than extremely weak. It would, in the context of certification, it would have to be.
What I mean is they're bound to fail because
yes.
they're so extremely weak. Is that?
So there would have to
I'm
be,
trying to think what are the other ways one could go about it.
So there would have to be a basis for it, I would say, my lord. So using just an asylum case as an example, there may be a situation where an individual had stated that he was at risk of political persecution, and he had stated that the authorities were looking for him, and the Secretary of State did not think that that was credible. So they may refuse the claim on that, but on the basis of certification, they wouldn't be able to certify on that, because that is something that would always have potentially the ability to succeed in front of an immigration judge if it's on credibility, which is one of the reasons why claims are taken at their highest. Frequently, and in fact in this case, what one can see that the reason the Secretary of State certified it wasn't on the rejection of the claim altogether, it was because of the sufficiency of protection and internal flight. But it's not, I would submit, sufficient to simply say that sufficiency of protection when one is considering why it is bound to fail on sufficiency of protection, the Secretary of State must consider why, on those particular facts, it is incapable of succeeding. Now, it might be different if it's a situation, and I'm going to come to it in a moment, where, for example, there is no doubt that there is sufficiency protection across the board. So we're talking about, hypothetically, a removal to, another European country. In those circumstances, I think it would be easy to say there is blanket sufficiency of protection, there is no possibility of succeeding in your claim. But when there are circumstances, and we'll come on to this in a moment, where, although there may be general sufficiency of protection, there are categories of individuals, categories of people, or certain facts which may lead to the opposite conclusion, and therefore may permit a hypothetical immigration judge to allow an appeal, then when dealing with certification, the decision maker has to deal with that, which, when we come to it, I will submit that she didn't. Just back on FR, paragraph 99, it's only better to refer you to this, and it's also a useful analogy. That the court refers to the possibility of certifying a claim as totally without merit as a similar procedure that a decision maker must go through. So it's the process of refusing permission, but also certifying it as totally without merit. And so the decision maker has got to think and give reasons why it's not just weak, it's not just likely to fail, but why it cannot succeed.
Those might be the same reasons as why you've dismissed it. I mean, dismissed the claim itself on a totally without merit, let's just say, because it's in mind. You might refuse permission to appeal, let's say, because you think it's a hopeless case, and you'll say, I think it's a hopeless case. And then you might at the end say, for all the same reasons, I consider it totally without merit. In other words, it does meet that higher threshold for the same reasons.
Yes. I mean, what
I'm saying is that might be something you find. Yes,
and in some circumstances that may be the case. And I think that, and I don't dispute that when considering the certification, one does have to look back at the previous reasons in the refusal letter to see what has been relied on, and if they are show that the decision is incapable of succeeding. The final point I just want to go back to, and again it's covered by Ms. Payne, is what taking the case at its highest means in the context of capable of being objectively well-founded. And I think it's covered in both FR and SP Albania. But if I can take you to SP Albania again, I know we have looked at it, but it's so central to the issues. I think it's important to just consider the ratio of the case, but also how it was applied. And it's at tab 19, paragraph 25 at 474. We have already looked at paragraph 24 and 25. It cites the guidance that was given in FR Albania. And of course, and confirms, which is not in dispute, it's not just simply accepting everything that an individual said. So an individual says, I'm going to be at risk if I'm returned. So that's not capable of being objectively well-founded. There's got to be something more than that. So in paragraph 25, it's to consider the test, to consider the claim that's been put forward, including all of the information that has been provided. And of course, that goes back to the anxious scrutiny test, has to consider everything. And if there is material which is capable of being objectively well-founded and sufficient to establish a claim, doesn't mean that they'll win, but just means it's not bound to fail. But even if that's not accepted by the Secretary of State, then an opportunity to have that evidence tested should be provided. Now, in this case, in SP, the court did find that the there was evidence capable of being objectively well-founded. And I think it's illustrative to see what they found was capable and what they found wasn't capable. Because in paragraph 26, and this was a risk of the individual was a victim of trafficking. And at paragraph 26, we'll see that she claimed that the individual who trafficked her was a member of a gang. But on her own case, she said that it was only her fear that made her think that. So she had no basis for this evidence. It was just her own fear, and that nobody else had been involved in crimes committed against her, and she had no basis that his friends were involved. So the fear was entirely subjective. It wasn't capable of being objectively well-founded. But what was possible to be capable, what was potentially capable of being objectively well-founded, was her answer in her screening interview, and it's at paragraph 27, fourth line down, when she was asked why you can't return to your home country, and she said, "I'm afraid of the person I used to work for. He raped me, my family found out and helped me to leave." And then this is a key point. He said that if I reported him, then he would have my children taken away. What do you feel will happen? I'm afraid that if I return, he will take my children and be violent towards me. And at paragraph 28, we see that the court considered that there was no consideration of why she feared that the children would be taken away, who would take them away, what was the connection, and whether there was sufficiency of protection, and this was a trafficking case, of course, whether internal relocation was in part dependent on investigation of this case. So the reason I'm emphasising this is because it's really very slight evidence. It wasn't reason. There wasn't any further evidence given. She feared that her children may be taken away.
He had said that they would take the children away.
Yes, that he might take the children away. Sorry, yes. But it wasn't a case where that was backed up by anything else. But nonetheless, that was capable of succeeding on appeal, or certainly that was the conclusion. And at paragraph 33, we will see that the conclusion of the court was that this was not an appropriate case for certification.
The process of reasoning was slightly different. It was that the issue hadn't been followed up. It wasn't a question of accepting or not accepting what had been said. It was a non-investigation issue, wasn't it?
Yes, but the final conclusion of the court was that this was not an appropriate case for certification. So the certificate was quashed and set aside. And you see there actually, and we referred to that before, substituted decision of the court quashing the certificate, refusing her asylum claim and certifying it as clearly unfounded. Wasn't remitted back to the Secretary of State to reconsider.
But I don't understand, at the moment I don't understand. As my lord has picked up, end of paragraph 28, these questions were never asked or answered in sufficient particularity to demonstrate that her case was being considered at its highest. You're not running a case that your client wasn't asked enough questions.
No, but what the court found that these two answers, these two sentences, were nonetheless sufficient. No further questions were asked to find out if it was capable or not, and that alone was sufficient for the certificate to be quashed. So it's an evidence of how little is really needed for a claim to be capable of succeeding. If I move on and just move back to FR, because likewise that had a consideration of the evidence and what was found to be capable of succeeding on appeal. So it's tab 16. And starts at page 403, so paragraph 93. And Mr. Payne very kindly took you through the facts previously. I mean, so this was a case where it was a blood feud. And the question was whether his evidence that his persecutors were sufficiently powerful so that they would have a reach over Albania, and there'd be no sufficiency of protection. And it failed at first instance. You see at paragraph 93 in the final sentence, because the first instance court found that the evidence that the family were powerful without any further explanation, so that was just as an assertion, did not give rise to this inference and was consistent with their having a reach with only a limited area. And the court continued at paragraph 94. They accepted that it was unparticularised, and it may mean that ultimately a tribunal will not accept that they have a reach. But the question was whether the unparticularised submission that his persecutors did have connections to the Democratic Party and to the judge who tried his family was capable of succeeding. So he'd given an objective basis. He might fail on appeal, but it was his assertion, his factual assertion, was sufficient to succeed on certification. So if I turn now to some of the Albanian case law and evidence, and I don't take any issue with my learned friend's summary of the test for sufficiency of protection. Of course, it's well established in Horvath. But how it is applied in cases, it always has to be fact specific. And there will be some countries where there is effectively no sufficiency of protection because there's no functioning government or justice system. There will be some countries where there's effectively always sufficiency of protection. And then you will have lots of cases, lots of countries that are in the middle, where there is in general a sufficiency of protection, but there will be certain categories of individuals or certain individuals with certain facts who may not be able to obtain sufficiency of protection. And Albania, I would submit, is one of those countries. So it's generally sufficiency of protection, but it's fact specific. And there are various country guidance case law that deal with the question of sufficiency of protection in Albania. None deal with the question of male trafficking victims. There is apparently a country guidance case that is being heard at the moment, so there may be one in the future, but currently there's nothing exactly on point, but it is the principles that are contained in other country guidance case law are illustrative and are clearly going to be applied by the hypothetical immigration judge who may be determining the appeal. And if I can take you to four very, very briefly, because I'm aware of the time. EH Albania, which is at tab 13 of the bundle, and this was a blood feud case, risk from a victim of blood feuds. The entire case has not been included because it's very lengthy, most of it isn't relevant. But what is relevant is the general conclusions of the tribunal on sufficiency of protection in Albania. And that's set out in the head note. And it starts at paragraph 3. And it's accepted that there's no sufficiency of protection in particular areas of northern Albania where there's canon-related blood taking. So that's not relevant to this question. But the final sentence says that internal relocation to an area of Albania less dependent on the Canon may provide sufficient protection, depending on the reach, influence, and commitment to prosecution of the feud by the aggressor clan. So it's accepted that no sufficiency of protection in that particular, in the northern area of Albania.
But what has this got to do with our case?
It's illustrative of the fact that there is areas of that sufficiency of protection does not apply across the board in every scenario in Albania.
These are, we're not concerned with northern Albania, we're not concerned with blood feuds.
No, my lord, but they're relevant because a blood feud is an individual who is a victim of a criminal act or potentially a victim of a criminal act. Whether the society, whether the judicial system, there's a functioning judicial system works across the board is relevant to the question, especially bearing in mind there's no country guidance case law specifically on.
All right, well, I'm probably calling you to spend more time on this case.
So, yes.
Otherwise would have done, but I really think a UT decision, which is not a country guidance case 15 years ago about a completely different set of facts, is probably not going to shine very strong light on our task.
No, but it is still country guidance, though, this case. So
it is a country guidance.
Yes, it is a country guidance case. And I won't take you to it, but paragraph 69 to 70, 237, 238 does refer generally to the difficulty in internally relocating in Albania because of the size of the country and the need for registering with the government registration. The next case is AM and BM. That's in tab 9. This is still a relevant country guidance case law on the risk of trafficking to women. It predates TD.
Which case are we on?
So AM, sorry, it's at tab 9. It predates TD, but it wasn't overruled by TD. So when a new country guidance case comes out, sometimes it removes the country guidance designation of an earlier case and sometimes it builds on it. In this case, TD built on the earlier findings of AM. And the relevance, I just want to take you to a few paragraphs in AM and BM. Paragraph 181, which is at paragraph page 167.
167.
Yes, 167. And it refers to the high levels of corruption. And then paragraph 182. At the bottom of the page, 167.
I don't want to hamper you unduly, but I do have some apprehensions about. I mean, this is now 16 years ago.
Yes, but yes,
What is the? What I haven't. I obviously haven't yet grasped the reason why you're taking us to this.
Because it confirms, because AD builds upon the findings. TD builds upon the findings of AM and BM. I'm only going to refer you to this paragraph and one other paragraph. At 182, it confirms that although there's in general sufficiency of protection for new incidents, whether there's sufficiency of protection from former traffickers is fact specific.
Yes. Top of the next page, we accept that there's considerable corruption in Albania, but we conclude that the steps taken by the Albanian authorities are sufficient to meet the standard of sufficiency of protection as set out in Horvath.
Yes.
What else do we get?
From trafficking from new traffickers. And then it carries on, however, when considering the issue of whether victims of trafficking have sufficiency of protection from former traffickers, we consider that issue must be fact specific. So it makes a
This was the
distinction.
2012 case, and our trafficking was in 2020 something, wasn't it? 2023.
Sorry, in
Wasn't our trafficking in 2023?
yes.
So there'd be new traffickers, wouldn't they? Maybe I haven't followed it.
I understand the point, which is that if you've been trafficked once, you've got to look at the people who trafficked you.
Yes.
But I nevertheless think we've probably got more
Sorry.
pressing issues to,
Yes,
to
no,
be
I shall-
dealing with than these old cases.
So I shall move on to TD, and I'll be very brief on that because my friend has dealt with most of the key points in there. At tab 15, at page 342, paragraph 95. It refers to the risk of re-trafficking by the same individual or gang who exploited the FOT, victim of trafficking originally, and that's for concepts. It's clearly not a fanciful notion.
What year is this?
2015.
So this is 2015, but this is still the current country guidance case law. And then you were taken to the, paragraph 119, which is the country guidance, the binding country guidance that any immigration judge needs to consider. And the conclusion at 119 that starts at 350, at 351D, that although there is in general a Horvath standard of sufficiency of protection, it will not be effective in every case. And so particular circumstances must be considered. Paragraph G, that re-trafficking isn't reality, depending on the factors that led to the initial trafficking. And then H again, whether they are an individual at risk of persecution and will be able to access sufficiency of protection will depend on their individual circumstances. So again, it accepts that it's fact specific. And because it's binding case law, because it's still current country guidance case law, any hypothetical judge determining this appeal must follow it unless there are cogent reasons to depart from it. And the Secretary of State has not argued, does not argue that there's cogent reasons to depart from it. Indeed, her own policy note accepts that AD is still good law on that point.
Given that this is about trafficking of women, have I understood the submission correctly, which is that it's fact sensitive in every case?
Yes.
The fact that a place is Horvath compliant doesn't mean that there may not be gaps.
Yes.
And therefore one needs to look at the evidence that is put forward in the specific case.
Yes, that is entirely, and on that point, I shall
have
move.
I missed something?
Yes, I will move very quickly. I just want to, and I'm not going to take you to it, AD and others against Sweden. Can I just make the point without turning to it and ask you to look at paragraph, not now, but paragraph 71 to 78. I think you have looked at it, but what the court didn't hold that there was always sufficiency of protection. What they said was it wasn't so bad that there was insufficiency of protection for everybody who was a victim of, who was targeted by criminal organisations. And on his particular facts, which included the fact that he had good connections with the judicial system, that the authorities had previously acted on his reports, and his persecutors were unidentified, so there was nothing limited to what they could do. There was no reason to depart from it. So I'm going to turn now to the facts. And again, my friend took you through most of the interview. I just want to take you to three additional points in the interview and the witness statement. So if I can turn to the supplementary bundle. So tab 2. So tab 3. And question question 34.
Page.
Sorry, page 23, my apologies. Question 34, so this is once he'd been taken to, when he was in Holland. How did you become aware that these how did you become aware that these men had power over the police and influence? And it's the final two sentences. And with Arbon, I only realised it on the journey to get here. When I was in Holland, I realised they were involved in stuff that was not legal and lots of other people involved in it too.
Why are you taking us to that
Sorry?
question? Why are you taking us to that question and answer?
So I'm taking you to that question and answer to show that it was part of a gang, it was part of a group, there was lots of people involved. Because there is some suggestion, and when one looks at the certification decision or the refusal decision, it reads as though they were separate incidents, that he was taken, got a job from Arbon, he then went to Holland, and from Holland he was then taken to the UK. Whereas if one reads the evidence as a whole, and it's easier when we look at the statement, we'll see that it was one continuous process and that the individuals were connected.
Yes, I'm sorry, but on the face of it, the answer is not an answer to the question.
No, I
It doesn't.
appreciate.
It doesn't. I mean, unless I'm missing something, it doesn't offer any support for the contention that these men, Arthur or Arbon, had power or influence over the police.
The relevance is the inference that to be drawn, namely that it was a organisation, a bigger organisation rather than one individual. When one looks at the evidence altogether, we'll see that his evidence was that this was a well-connected criminal organisation with cross-jurisdictional links.
All right. Well, that's the first of those questions.
And I think if we turn, I'll turn to the statement because I think it's probably easier rather than just taking to discrete points. And the statement, the claimant's statement, is at page 51. It's tab 6. And if I take you first of all, paragraph 52, it's at page, paragraph 12 at page 52.
This was
So
cited
this
in
is-
your skeleton, wasn't it?
Yes. So this is when he met Arbon. So he was told him at the time he worked for a powerful organisation with strong links to the Albanian government that arranged for people to go and work abroad. So that was a fact that was told to him. So we don't know, it may not be true, but this is just whether it's capable of succeeding. And the evidence that he provided is that he was told that it's a powerful organisation. Then further at paragraph 15, he was taken to a house in Holland where there were 5 other people there. So it wasn't an individual situation. He wasn't the only person that this occurred to, again, suggesting of a larger operation. Paragraph 16, that he was threatened. And then over the page, at paragraph 24, and this was after he was taken to the cannabis house. And the person who was in charge spoke to somebody on the phone, told him that he owed them a lot of money, and said that the organisation didn't operate in the UK only. They had strong links to people in powerful positions, and that he'd be killed if he didn't pay up the debt or work for them. And finally, at paragraph 36, which is at page 56, his evidence was that the organisation who trafficked him is powerful. They had a well-organised network abroad. I'm certain they are well connected in Albania, as they said. Now, taking all of that evidence together with the interview, shows that it's not just the MB's, the respondents' assertion that they were well connected, that it is backed up by not only what he was told, but by the method of recruitment, the fact it was a well organised operation, that it clearly had links, transnational links between the UK, Holland and Albania. And in light of that, it is capable of establishing an objective risk. It's capable of demonstrating that his traffickers were sufficiently powerful that they may have reach and influence over the authorities. And as again, I say, it doesn't mean it will succeed, but it's certainly more than when we looked previously at SP, when the individual, the appellant, simply was scared that the trafficker was part of a gang. It has a concrete factual basis. So if we turn to the certification decision, that's at page, the refusal decision, and that starts at page 262 of the core bundle. And the facts at page 269, as we've already stated at the start, your claim has been considered at the highest. So as if the events that you describe occurred as claimed. And then the risk, the assessment of future fear is set out at 269. Says your fear relates to two men, Arthur and Arben. Says that you met Arben online, that's the fourth line down. He then arranged for your journey to the UK and promised you employment. And you've not had any contact with Arthur or Arben since leaving Albania. You failed to demonstrate the people you fear have the ongoing motivation. It's noted you have not had any contact with Arthur or Arben since leaving Albania, and you've not received any threats since leaving Albania. Now, that is at the very least incomplete, because although he didn't have any direct contact with Arben, his evidence has always been that he had contacts with Arben's men. It was the men in Holland that were harbouring him and then took him to the UK. It's also simply incorrect to say that he had no threats since leaving Albania, because as we've already looked at, he had threats both to force him to get on the boat, but also threats to work in the cannabis house. He was told that he would be killed if he did not. There's no reference to the fact that this wasn't an isolated incident or trafficking by an individual, but by a well-organised gang. Now, the decision then goes on and consider sufficiency of protection, accepts general sufficiency of protection. States that the decision maker doesn't accept that he wouldn't have protection, and internal flight is considered at page 272. Again, that stating, this is 5 paragraphs down, you failed to demonstrate the moneylender and the person who brought you to the UK have any power or influence to be able to locate you if you moved to another area. So that is the refusal of the decision, but there's no consideration in the refusal of the decision of the specific facts that I've already referred to, the extent of the organisational involvement. And so when one looks at the reasons for certification that starts at page 280, which refers to the fear of a man who arranged your travel to the moneylender and the man who arranged your travel to the UK, states that you've not demonstrated or given evidence to support your claim that they hold any power or influence over the authorities in Albania.
Where are you reading from?
Sorry, tape 280. So under the reasons for certification, reasons why your protection claim is clearly unfounded, third paragraph after down from there. There's no consideration of his specific evidence, his specific facts, either within this section, the fact that he was trafficked from Albania to the UK by a gang, no consideration either in the certification, which is relevant to risk, or even referring back to the section on substantive refusal.
It does talk about, it talks about above sections, so it does go back to substantive refusal, doesn't it?
Yes, yes. What?
And that's on relocation. Oh, both of those paragraphs, both of the last two paragraphs, have an explicit reference back to the rest of the letter.
Yes, but which is why I took you to the start of the letter, the substantive reasons for refusal.
Yeah.
To show that there wasn't, even in those sections, there wasn't consideration of the specific facts, the facts which may mean, even if the Secretary of State refuses his claim, may mean that it's not bound to fail. And those are the particular facts about the gang, the cross-jurisdictional gang, which is the point that and the reason this is important, of course, is that was a point that the Upper Tribunal judge emphasised in her
What is
judgment.
said against you is that all of these points may be interesting and whatever, but they go to measuring the extent of the risk that he might have faced, and that seemed to be what the Upper Tribunal had in mind, that he'd been trafficked before, so he was at greater risk of being trafficked again. But the Secretary of State's answer to it is to rely on the Horvath sufficiency in the internal relocation, so that in a way you're on tracks that aren't meeting. So you're talking about risk, and they're saying, well, taking your case at its highest, the risk can be mitigated or is vanishing or non-existent or whatever. So how do we deal with that?
Because the two things go together. The reason, all of the guidance, all of the case law shows that there's in general sufficiency of protection, but there are gaps. And one of the potential gaps is that if individuals have influence over the authorities and have the ability to locate somebody. Now, his evidence that it is a well-organised...
You say that's enough, is it? Just the fact that it's more than Arjun. There's some others around, and you can infer that it was part of a gang. And it was a wider network of serious crime.
Yes.
That's sufficient, is it, to get you into one of the, arguably, possibly, into one of the exceptions?
So I would argue that it is, because we are only looking at whether the claim is bound to fail or not.
I've just been trying to work out what it is that you say is the thing, the hook that gets you in, and it's the fact that there was evidence that it was an international crime gang, across borders, more than just Arjun. And that means he might be in a gap.
Yes. And I think on that basis, I can probably deal with the judgment of the tribunal relatively briefly.
Sorry. Could an FTT judge find that he was part of a big gang on that evidence?
Well, I would certainly say that he or she could. I mean, the basis that the evidence that was provided was that there was a link between Arben to the people in Holland. The people in Holland called up. So the evidence was that Arben had a business in Albania sending people overseas. It was a well-established business. There was people...
Until he gets to Holland, there's no question of trafficking.
he's not trafficked. Well, he's recruited in Albania. That meets the definition of Albania of trafficking. So he was recruited on a deceptive basis, and this was accepted in the conclusive grounds decision. And it was on that basis he travelled to Holland, and from Holland to the UK, Holland, he was trafficked to the UK on the boat. But recruitment falls within the definition of trafficking as well. One doesn't have to be physically transported or moved from one place to another. But the evidence was that there was the people in Holland called up Arben. They were his men. That was the answer that he gave in the interview. So this shows, and then he was taken to the UK, where he was taken to a cannabis house, where he was then arrested. So it's clearly, it's not separate individual events. It's one concerted course involving several people.
Yeah, I understand your point is that although he thought he was being helped to get in here illegally.
Yes.
And his case was that in fact it turned out that he was completely deceived and that he was, although he didn't know it, being trafficked in order that he could be used in modern slavery.
Yes.
Yeah.
Because it was for exploitation, and that was accepted. We haven't looked at it, but the conclusive grounds decision, which is at page 5 of the supplementary bundle, and accepts he was a victim of modern slavery in Albania and the United Kingdom. And it does go through the various stages, including the being recruited in Albania. And the consideration starts at page 11. I don't want to take you to that because I don't think it's not in dispute. That was the background of the evidence. So turning to the judgment.
But I mean, just thinking about bound to fail. I mean, I don't want to. I don't want to introduce any air of flippancy into this. It's all very serious. But I mean, in a sense, it's not good enough for somebody in this position simply to show that they have an argument about something. They have to have arguments that are capable of succeeding objectively to a degree that means that it can't be said that they're bound to fail. I mean, you know, the fact that one might score 2 goals in the course of a match is not going to help you if you're at the end of extra time and the other team has scored 9.
Yes.
I mean, so we're not looking just to find whether there is a, some potential argument about something. We have to look at the whole complexion of the situation and the issues that would be before the first-tier tribunal, and what perceptible possibility there is of your client succeeding on any of the issues which he needs to succeed on in order to make good his claim.
Yes. So it was certified, the claim was certified not on the basis of risk, but on sufficiency of protection and internal flight. I have addressed the sufficiency of protection on the basis that his evidence, which maybe is capable of being accepted, is that they were a cross-jurisdictional gang that potentially had influence with the authorities. That was the evidence that he was told, that they had links with the authorities. So that is possible to get him over the sufficiency of protection.
So it's only the next, the fact that they're cross-jurisdictional isn't the issue, it's the links with the authorities. That's the bit that you're relying on, because that would feed into being a gap in the sufficiency of protection.
Yes.
But it's just his words, just he says that's what they said to him. Is that
Yes.
right?
Yes. But, I mean, we are considering an asylum appeal where there is very rarely any direct evidence. So it is usually just what one person has said. And then that is heightened by the fact that we are dealing with the certificate as well. So it's whether, could an immigration judge hear that evidence hear all of the facts and consider, yes, maybe he does fall within a gap of sufficiency of protection. And I would say yes. With regards to internal flight, there is evidence within the Secretary of State's own policy evidence that Albania is a very small country, and it's very easy to find people. It's very easy to locate them and reach them. I can give references to that if the tribunal, if the court wishes. It's at the supplementary bundle, and page 200. Starts at 200 and paragraph. It's 13.1.1.
19 point.
Sorry, 13.1.1.
Thank you. I've got it.
That's evidence of what a small country it is. It's a little larger than Wales, population of around 3 million. And then over the page at 202, 13.3, which is about anonymity. It's entitled Anonymity in Albania. Now, this is the evidence that the Secretary of State has put together. And you'll see that it's the evidence is it's a very small country, 13.3.1 to 13.3.5. And it's from various sources saying that it's easy to track people down, it's easy to locate them, it's easy for traffickers to find them. It's variations of the same theme. So 13.3.7, you'll see that if a person is in fear of their trafficker, they could be placed in a state-run shelter and receive state protection. However, and this is a distinction.
We leave that 13.3.6. I mean, it seems to be a bit of a mixed picture, this.
Sorry?
A bit of a mixed picture.
It's a mixed picture. I mean, the majority seems to say that we can find, individuals can be found, but of course there is 13.3.6 that says it's not always that easy. But again, it's the hypothetical immigration judge would be looking at all this evidence. It's certainly not all one way. So it doesn't mean it's bound to fail. And with reference to the reference that they could be placed in a state-run shelter, and this is a distinction between men and women, and this is why sometimes it can be difficult to apply evidence relating to women as evidence to the risk for men, because in fact men are not accommodated in the trafficking shelters in Albania, and that's accepted by the Secretary of State. Again, in her guidance, evidence at page 109, 4.6.2. So it says that they're not currently accommodated in shelters. They may have access to rented accommodation or rent subsidies, but the relevance of the shelters is because the shelters can also offer protection. So the respondents' evidence that they have a reach, that they are powerful, combined with the background evidence at the very least shows that people can be tracked down, shows that the internal flight is also not bound to fail. So if I turn to the judgment, which starts at page 81. And if I can go through it relatively quickly. The paragraph 21, see that the judge sets out the certification decision in full, and correctly does notes at paragraph 22 that's the decision. So it's not the decision to refuse, it's the decision to certify. That's what's under challenge. That's at paragraph 22 at page 87. Paragraph 23 to 29, she sets out the legal test, which is not, there's no suggestion that she misapplied herself in any way. At paragraph 30 to 32, she refers to the country guidance case law, correctly notes that there isn't anything on male victims of traffickers. Paragraph 33, she refers to the respondent's own evidence. So she takes on board the Secretary of State's view of the risk to male victims of traffickers.
These are extracts from the CPN that you
Yes.
just referred us to.
Yes.
Other extracts.
Yes, that's correct. And of the Secretary of State's general view is that men are not at real risk of serious harm or persecution, male victims of trafficking. But at paragraph 3.3.4, you will see that the Secretary of State does accept that they may be at risk on a variety of factors, including intent and reach of their traffickers, set out at page 90, set out in full.
And that the reach of their traffickers in that catalogue of things that risk may depend upon is the only one that you can pray an aid, isn't it? Age, education, skills and employability, area of origin, health or disability, availability of a support network. He scores reasonably well on all of those, doesn't he?
Well, his evidence was that he was thrown out of home because of his gambling problems. So there's no, on the evidence that was before the decision maker, there was no.
He was in regular contact with his sister.
Yeah. So his sister was in I think in the UK. I think he lived with his sister in the UK.
He's regular contact with his mother.
I'm informed that he was in regular contact with his mother in Albania. I don't.
Page 21.
I don't
Yes.
dispute that. But yes, no. Certainly, the most important factor there is the intent and the reach.
Well, actually,
Other
more specifically, the reach,
Yes.
because there's no evidence of the intent.
Other than he'd been told that he had to pay back the money, otherwise he would be killed. And the discussion, analysis and conclusion starts at paragraph 36. There's a question about whether it would be academic, which I don't need to deal with.
Do you support the sentence in 36? She fails to separately consider whether or not, notwithstanding her reasons for refusing the applicant's claim substantively, the applicant's claim was bound to fail.
That's a submission. That was the submission.
Yes,
Being
that-
cons- yeah.
So yes, that was the
And is
submission.
that a submission that you make?
So it's clearly in the certification decision that the decision maker referred to the correct test. But when the decision maker considered whether it was bound to fail, what she didn't do was factor in the relevant all the facts. So she just referred back to the decision to refuse the claim. So the findings of the immigration judge, the key ones really, before that, paragraph So 52 are, I think, the key factors that the immigration judge stated, sorry, Upper Tribunal judge stated had not been taken into account.
I'm sorry, I'm just lagging a little bit. I'm just looking at the grounds for judicial review, which I don't think we've visited. And I think I'm picking them up at page 242 of the same bundle on this point. It was just arising from the first paragraph that we looked at and the submission that was being made to the UT.
Yes.
I think paragraph 46 on page 242, without me jumping backwards and forwards, is pretty much what says what the judge understood it to say.
Yes.
It was the first error that was being pointed out under the judicial review grounds was failure to consider whether the claims based on being a VOT were clearly unfounded.
Yes.
Okay, sorry, so I don't know whether there's anything else that we need to gather from what the grounds were. Ground 2 was detention was unreasonable and unlawful. That was it.
Didn't get leave for 2, did you? You just got
No.
leave for 1, which was the rationality
Yes.
ground, which is, I think it's moved on a little bit.
Yes, that's correct. I understand that it was previously in the administrative court, and then when the detention ground was refused permission, it was transferred back to the Upper Tribunal.
Okay, so if we're pursuing the arguments that were being advanced, we start with paragraph 46 on 242, and then we emerge into the substantive decision where you were just taking us before I interrupted you.
Yes, and we've already looked at the
paragraph
52
just for my note,
at page-
paragraph 36 at 91.
Yes. So yes, the ground that was pursued below was that it was irrational, not open to her, and failed to consider whether the claim was bound to fail, which appears to be what was argued below. I didn't appear below. But at paragraph 52, which is at page 94, I think going back to the reasons of the Upper Tribunal judge. And it is these factors that not only did the judge say the Social State failed to have regard to when considering whether it was bound to fail, but also, when certifying it, but also led to the conclusion that the claim was not bound to fail. We have looked at those, and so I can deal with them very briefly. The first is that he was accepted as a victim of trafficking, but it's not just that he was accepted as a victim of trafficking, it was that the trafficking was in Albania and in the United Kingdom, so across the borders. And then B, which is perhaps the most important one, that a judge could consider the sufficiently sophisticated nature of the operations in trafficking the claimant, trafficking the respondent, so that they were able to evade the authorities and or ensure that he couldn't seek protection. I accept that C doesn't add very much, the fact that modern slavery occurs in Albania. And the D is the additional fact that he was a past victim of trafficking, because that is relevant. It's accepted that once you are a victim of trafficking, then there is frequently a heightened risk, and that's, I'm not saying that's a proposition of law, but one of common sense, because those vulnerabilities that previously existed, that led an individual to fall into the situation where they are have been trafficked are frequently going to still occur on return, and perhaps even heightened by the fact that an individual has had the experience of being trafficking and all that that entails with it. So those are the findings of the immigration judge, sorry, the Upper Tribunal judge, that she considered that the Secretary of State hadn't had regard to when considering whether the claim was bound, when considering the certification, and also that led her to her conclusion that the claim was not bound to fail. She accepted, it is clear that at paragraph 53, that she took into account the general position of the respondent that the Albanian authorities are willing to and able to provide effective protection. She accepted at paragraph 54 that there is support and protection available, so she didn't ignore it, she had regard to it. But she considered that on his own particular facts, paragraph 56, the fact he's already been trafficked from Albania and the circumstances of that trafficking mean that the claim have power and influence over the authorities is not fanciful. Now, the use of the word fanciful, I would say, is capable. It means the same, it's capable of being objectively substantiated. So what she means is it's not hopeless. It's not beyond comprehension. It is a possibility. An immigration judge could find that the traffickers have power and influence over the authorities.
Can you help me? Have you passed by 56?
That is 56, paragraph 56.
That is. Just taking the first sentence, what is the correct question? I know this may sound completely daft at 4 o'clock in the afternoon when you've been making submissions all day, but what is the correct question which was not asked?
Is a claim bound to fail? And I think if one actually looks at paragraph 55 above that, because I know that there was some consideration of what that final sentence meant. These reasons are then imported into the respondent's assessment on certification. She does not add any further reference with any reason with reference to the applicable test. My interpretation of that is going back to FR Albania. So it's not simply that one says that the claim, there's no sufficiency of protection, it's not sufficiently the claim fails, but she has to, the decision maker has to explain why it's bound to fail. So that's the further reasoning that is needed.
It seemed to me that paragraph 55 was really the key paragraph in the judgment. And I just wanted to make sure that I followed your arguments on it. So what the UTJ says is she's satisfied, line 3, that the respondent has failed to ask herself, this is the point that she's making, whether or not the applicant's claim, and it's this bit, that there would not be sufficiency of protection as a result of his own particular circumstances, which include his vulnerabilities as a victim of trafficking, is one that's bound to fail. And the own particular circumstances that you have pointed to are the fact that when he was trafficked, you can infer that he was trafficked as part of a cross-jurisdictional criminal gang. That's the circumstances, is it?
Yes, and also the evidence that he gave that the traffickers had links and influence with the
That's
authorities.
subjective. That's his assertion.
Yes.
And we know we have to be very careful about that. We have
Yes.
to look at objective evidence. The only objective evidence that I can see here is that, or the only cogent evidence is that he was part of a cross-jurisdictional trafficking thing. He was trafficked across borders,
Yes.
starting with Arjun and then going through other people.
Yes.
And then she adds into that the generic evidence that she's referred to that says that where somebody's been trafficked once, they're quite likely to be they're more likely to be trafficked again. That's his vulnerability as a victim of trafficking.
Yes.
So there's nothing else to make
Yes.
him vulnerable. So that's it, is it? That's where we are.
Yes.
Am I right? Thank you.
And with regards to the remaining paragraphs, the judge repeatedly reminded herself at paragraph, well, we can see it at paragraph 58, that the respondent is entitled to conclude there would be a sufficiency of protection, but that does not mean that a judge properly directing themselves could not reach a different view. See at paragraph 59, she did refer, took into account AD in Sweden, took into account, cited the specific paragraph. And with regards to paragraph 61 to 63, it is clear there, I would submit, that the judge was accepting that there is, in general, a sufficiency of protection, but it may have gaps, which is the classic formulation. And in this case, the relevant gaps are relevant to the corruption, that is why the corruption is relevant, because this is not a case where there is a particular reason why the government or the police would not take action. The reason potentially why there wouldn't be sufficiency of protection is because of the widespread corruption, so that if the traffickers do have sufficient reach and power and influence, that is why he may not receive sufficiency of protection in his own, on the basis of his own specific circumstances.
I was just looking to see what the lineage is of the expression fanciful. It seems very largely to be the judge's own devising.
I think possibly, may I just turn my back on you? Junior, Ms. Sankey is referring back. I think when we looked at one of the country guidance case law, when looked at the risk of re-trafficking, the tribunal said that certainly the risk of re-trafficking is not fanciful. Page 342 of the authorities bundle. TD and AD. So it may be that's where that has come from. The word fanciful, or it may have been the judge's interpretation. I simply can't.
What is said at paragraph 95 of TD and AD? Second aspect of safety relates to the risk of re-trafficking by the same individual or gang who exploited the VOT originally. This is clearly not a fanciful notion. Now, where Parliament has given us a formulation of clearly unfounded. Not sure what's that bound to fail has been is time honoured as as it were an ordinary English expression of a more formal expression, but I mean, of course they all mean similar things, but fanciful does have a bit of a flavour to it. And I wouldn't, speaking for myself, base any decision in this case on it, but it just doesn't seem to me to be particularly helpful to start multiplying adjectives in a field of this kind.
I wouldn't disagree with that.
Well, I mean, having others may not agree, but the case is not going to turn on
Yes.
such a nice point. But
It would have been, and the Upper Tribunal judge has elsewhere used the correct terminology of bound to fail, which it would have been more sensible to use that throughout rather than the use of the word fanciful. But taken in context, I would submit that it's clear what is meant by that.
yes.
And the only other point is with regards to her conclusions on internal flight, which were dealt with in paragraph 67. And where she accepted that is the claim that he could not relocate as a result of the power and the influence held by his past traffickers, so again based back on his own particular circumstances.
That's the paragraph 55 point again, isn't it?
Paragraph
Oh, sorry, we're into
67, paragraph 67, sorry, at page 98. It's the same point, but it's just in the context of internal flight as opposed to sufficiency of protection, so it's all going back to the reach. Power, reach, and influence. So, taking all of those circumstances, taking all of the facts into consideration, and it may be that the judge could have expressed herself differently. But again, then we go back to the guidance at the start at AH Sudan that simply because a judge sort of expressed themselves differently does not mean an error of law. And I would submit that having regard to the country guidance case law, the absence of anything covering these particular facts, the claimant's specific facts, which have to be taken at the highest, and I would submit are capable of forming an objective basis for his claim succeeding, I would submit that the immigration judge's findings that the decision maker either failed to apply the correct test and or her findings were irrational because it was not bound to fail. Unless I can assist you any further, those are my submissions on the certificate aspect.
Yes. So we're now on to the mandatory order.
Yes, I'm going to have to be very brief. I will, so if I can just take you first of all, so the judgment is the remedy judgment is at page 72 of the core bundle. And if I can then take you to, sorry, I'm just trying to find the case of YZ China, because that's very much the starting point for consideration. And the Secretary of State accepts that whether the judge should make a decision for mandatory return, it's a discretionary decision. So the Upper Tribunal judge had I would submit, a great deal of latitude in that respect. Tab 12 is YZ China. If I turn to paragraph 1, just so you can very, very briefly, the facts at 217. It was also a deportation case. And it was based on Article 8. It wasn't a protection claim. There was a certificate refusing a right of in-country right of appeal. He had a out-of-country right of appeal, but not an in-country right of appeal. The certificate was challenged but in the meantime he had been removed, and the question before the court was whether it would be appropriate to make a mandatory order for his return. And the key passage is at paragraph 229, at paragraph 49, page 229, sorry, at paragraph 49. And where a person on the position of the appellant is removed from the United Kingdom on the strength of an unlawful certificate, the effect is to deprive him unlawfully of the in-country right of appeal to which he's entitled. And that should be the starting point for the court when considering whether to order the person's return. And it's a fact telling strongly in favour of the person's return, so as to restore him in the person he should have been under statute. But although there's no presumption, there's a wide discretion. But the particular circumstances of the case still must be considered. Now, in that case, it was to deprive the individual of an in-country right of appeal. Now, the position is stronger now because by virtue of the certificate, the respondent has been deprived of the right of appeal entirely. Now, in this case, the Court of Appeal didn't exercise their discretion to order return, and the factors that they took into account start at paragraph 51. One, that the appellant's removal appeared lawful at the time. Paragraph 53, which isn't relevant, but it was a separation from his child. Paragraph 54, this is very important because it was a highly important factor that the appellant could pursue an appeal effectively from China. So he could still have an out-of-country appeal. And again, paragraph 55, again, that it was an appeal about family life, and Article 8, which is very difficult from some other circumstances. Paragraph 56, the first instance judge had taken into account a public interest element because of the seriousness of the appellant's convictions. Now, the court said it's a matter for the judge, but the court would not have placed much emphasis on that, because if it were not for the unlawful certificate, he would never have been removed. He would have still been in the country. So the discretion was not exercised in favour, but as we can see, a very important point of that was the fact that he did have a right of country, out-of-country right of appeal. So if we then, there are other authorities as El China and Nixon, but I'm not going to take you to them because I don't have time. If I just go to the remedies decision now, which starts at tab 7, starts at page 72. The judge looked at the case law, paragraph 10, cited YZ China. Paragraph 12 correctly stated that the illegality, this is at page 75, the illegality of the certificate is the strongest point. He took into account the factor against the appellant, the fact that the removal appeared lawful. I have put a respondent's notice on that, but I've got 5 minutes to deal with it. And paragraph 14, that this is a persecution serious harm case and it wasn't bound to fail. That's also an important factor. And at paragraph 15, she did not consider the fact that the respondent intended to appeal and therefore could delay returning the appellant, or the respondent rather, was a relevant consideration to take into account. So having regard to all of the factors, I would submit that the discretion, which was very much open to the immigration judge, upper tribunal judge, and the deprivation of the right of appeal completely was something that weighed very heavily and was more than open to her. Dealing very briefly with the points raised by
So let me just,
Leonard.
I'm sorry, to just consider this basic situation, that this submission is only relevant if you've succeeded in resisting the appeal.
Yes.
If you haven't, then ground 3 falls away.
Yes.
So we're here in a world in which the first judgment is to, at least in its effect, has been sustained. So the arguments that you're putting in relation, and that the judge relied upon in relation to illegality, are upheld.
Yes.
Right. So
Yes.
we're here talking about a world in which, as before the judge,
Yes.
it's the certification is illegal,
Yes.
and therefore, if the certification is removed, what right of appeal do you have?
If the certification is removed, so if it's quashed,
Yes.
he would have a right of appeal to the first tier tribunal in theory, but that could not be exercised unless he was brought back to the UK, because he can't appeal from out of country.
He can't appeal from out of country. So, I mean, I'm sure you're on solid ground here, but I need to follow it through. So he could only appeal from in country.
Yes. So I don't know if you recall, my lord, at the start of my submissions, I did take you to some of the statutory provisions.
Yes, I do. I'm trying to understand exactly how they work in this case.
Yes.
So what you've succeeded in doing is you've succeeded in getting rid of the certificate.
Yes.
You're still subject to a deportation order.
Yes.
And what is it that you want to be appealing against?
So the appeal is not against a deportation order. The appeal would be against the refusal of the protection claim and the refusal of the human rights claim.
Right.
So when
And that is an appeal which you say is only capable of being exercised in country.
yes,
That's right. Well, everybody agrees about that, and I've caught up.
Yes.
So, in a sense, you're saying if I'm not allowed back, then I have no ability to challenge the dismissal of my main claims at all.
exactly.
Even though the attempt to stop me from appealing has been found to be unlawful.
Exactly. So the
Well,
quashing
I'm
of
just
the,
wondering whether there's a short way through this. I mean, is it the case that ground 3 actually stands or falls?
Stands or falls with ground 1 and 2. I think ground 3 stands or falls with 1 and 2.
Well, exactly. But I mean, I realise it stands or falls one way, but I'm trying to see whether it stands or falls both ways. Namely, that if you win on the appeal, then there could be. I'm struggling to see what the argument is to. I'm sorry, with all respect to
Mr. Payne's argument is that as a matter of public law, it wasn't right for the upper tribunal to impose a mandatory order in these terms. Isn't that right? You just say you should have left the state to deal with the appeal, this appeal, and then it would have taken its course.
And if you remember at the outset, I said, to be honest, that it was, in practical terms, relatively academic, because if the Secretary of State succeeded on the appeal,
then that goes.
That goes. If my learned friend, the respondent, succeeded on the appeal, the Secretary has already agreed to facilitate the
Exactly.
return.
And we wouldn't need to do more in a sense than to record that, because you wouldn't need to be ordered to do anything. If it was on the face of a court order, you'd do it.
Absolutely. But
and so I don't want to miss out of anything, and I don't want to deprive you of the opportunity, for example, of using something in ground 3 to support your other arguments or whatever it is, but they seem to be quite discrete. And if I've understood this correctly, ground 3 follows inevitably from our conclusion in relation to grounds 1 and 2, and that if you succeed in defending the appeal, then you'll get back.
Well,
I mean, is that where we've got to?
That's argued.
Well, you'll have the advantage of the Secretary of State using best endeavours to facilitate your return.
yes. I mean, if that is the undertaking of the Secretary of State, then
Yeah.
I mean, we would.
Yeah, I think that was the position before the Upper Tribunal, and it remains.
Yes, because the whole thing was about appeal rights, and you just weren't prepared to bring him back until you'd had your appeal determined.
That's right. And that's the error. That's what we say was the error.
Yes.
Just in response to that, the correct thing to do is what happened, in fact, because the immigration judge has to make a finding on the basis of the situation at the time, which was as difficult as quashed.
No, I appreciate, but it
Yes.
seems to me that by the time it's reached this point,
Yes.
and there is going to be a decision on the Secretary of State's appeal, that will sweep up ground 3 as an inevitable consequence of our conclusion on grounds 1 and 2.
Well, in light of that, if I could just turn my back.
You're not missing something.
No.
Yeah. I think we're all happy with that.
There's a nice historical issue about whether there may be a nice historical issue about whether the Upper Tribunal was right or wrong to order what it did. And we may or may not decide to go there.
Well, I think I know where we might not decide to go, in the sense that we wouldn't really have necessarily had the fullest argument about it. But I think we've probably reached a point where we've got enough to be thinking about on this.
Certainly. I had raised a respondent's notice, but obviously there is no need to go into that because that's not going to be relevant in light of the undertaking now. So,
Well, look, Ms. Lawton, thank you very much, and also to Ms. Lankeys, obviously.
thank you. Unless I
Thank
can
you.
assist you any further, there's my submissions. Thank you.
Thank you. Yes, any reply?
2 points, my lord. First of all, just to draw your attention to paragraph 71. I'm not asking you to turn it up because I've taken you to it already, but in the case of AD versus Sweden, page 498, paragraph 71, it just confirms that there's sufficient protection in relation to criminal organisations, because there's been a lot of focus on the concept of organisation. The second point is that when you go back over the interview, you will see that the focus of the respondent's claim in terms of influence exerted is on Arben and Arthur. They're lumped together. It's on them as individuals, and the Secretary was entirely correct to deal with it as such. And the issues as to the potential trans jurisdiction organisation is, we say, just simply a speculative and a bad point. The third point, my lord, relates to the Secretary of State's bundle. So it's not really a substantive point, but it's just, if I maybe to end on a positive note in terms of bundles. Having gone through the emails, my solicitor has found an email at 4 p.m. on Monday from your clerks requesting the bundle.
Well, could we? I mean, is this something that can be dealt with in the letter that's going to be?
Oh, it was just because my solicitor was sitting behind me, and just I wanted. Well, it can be, but it was just that it was sent. The reply and the bundle was sent at 5:20 that day.
To my clerk.
Yeah, and there's an email. We have the email confirming. So perhaps it bounced back or something.
I'm sorry. I had obviously made my own inquiries before raising the matter with you, and I think I'd like to see all this in black and white.
Absolutely, my lord.
On this point. If there's anything for me to withdraw from what I've said earlier, I'd very gladly do so.
Yeah, absolutely. It was just really for those instructing me to have made the point. But we have a letter already drafted with the email, so we'll send that through.
Well, I'm sorry to add to your work, but in particular in relation to the forms of bundles and so forth, it really makes our work. Globally speaking, it makes it very much easier if we have standard compliances.
Absolutely, and to be honest, whatever happened 2 days ago, you ought to have had the bundle from the outset.
Well,
which I apologise.
Thank you for that. Now, my lady has something to say.
Yes, please may I ask you, Mr. Payne, forgive me if it's me in the slow lane, but I think we did finally get to grips with what the connection is between the factual case and the suggestion that the claim is not bound to fail. So the connector was that on the evidence that has been produced by this respondent, he says he's been trafficked across borders by a criminal gang, and that is a chink or a bridge or a possibility to say that the criminal gang has power and influence which would possibly put them into a gap in the protection and possibly mean internal relocation is not an option. Can I just have 2 sentences from you, please? I mean, you said just now, which was, it's speculative and a bad point, but can we, because if that is the case, and I think that is the case, it would be helpful to me just to have a couple more sentences, please.
Absolutely. So the first point is you've seen the country guidance cases in relation to trafficking, albeit women. You've seen the AD versus Sweden point. All those cases indicate that simply by reason of being trafficked, that of itself doesn't give rise to a real risk of harm. So the fact of being trafficked per se, and obviously the concept in terms of trafficking is international trafficking.
So that was my point. There's always going to be an international criminal facet to it. Okay.
Yeah. And so if that was a factor that brought into question or brought people into a sort of category where the sufficiency of protection didn't cover it, yeah, that would be inconsistent with all the case law dealing with trafficking and dealing with the position in Albania.
The point is not, I mean, as you say, gangs are, that's what it's about.
Yeah.
It's gangs who have, in high places,
yeah,
that we're really focusing on here.
That's right, and to be honest, my lord, as I said, it absolutely gangs, but also in this case, the focus is on the individual, Arben, and obviously we as lawyers can look at the broader organisation. But when I took you through the interview, the organisational comments or the comments in the interview related to events. If you remember, he said, "Well, I'm not sure if they were affiliates or how they were connected to Arben." So, in terms of the case, has the claimant has the respondent provided a foundation for considering that Arben has influence over the authorities? On his case, on his evidence, he hasn't.
Very helpful.
Thank you very much. Thank you for your patience.
Well, thank you all. Been very well argued, if I say so. I'm afraid that it's unlikely, once we've thought about it all, that we'll be able to give you our decision in this matter by the end of this term, which only has a few days to run. And after that, to an extent, the Constitution scatters. And so it may very well be, although we won't delay unnecessarily, that it'll be the beginning of next term when you actually receive a decision in this matter. Can I just, for those who are not already automatically familiar with this, say that our decision will be contained in judgments which will be shared with the parties and their legal representatives in draft. Please observe scrupulously the embargo that attaches to the receipt of draft judgments, and use the opportunity, please, to do 2 things. One is to identify any factual errors or typographical mistakes that have slipped in, and let us have a list of those. And the other is to agree a draft order that reflects our decision. I think that concludes the day. And can I again repeat? Thank you for working to make sure that we've heard all the arguments within the day.